Hello, everyone, and welcome to Family Violence Appellate Project's webinar. Before we get started, there's a few logistical notes. If you have any technical difficulties viewing this recorded webinar, please email us at training@fvaplaw.org. If this recorded webinar is not accessible to you, please contact us at training@fvaplaw.org, and we will work with you to provide the material in an accessible format. Also, MCLE credit is available for completing this webinar. To obtain MCLE credit, download the evaluation form located below on the web page for this training video and email it to training@fvaplaw.org or visit www.fvaplaw.org/training. While there, you can also browse Family Violence Appellate Project's selection of other recorded trainings. This training is about confidentiality and privilege, and it's a training for California domestic violence advocates, and we're recording it in 2018. What is FVAP? The Family Violence Appellate Project provides free appellate representation to low and moderate income survivors of domestic violence throughout California in cases involving restraining orders, child custody, and other domestic violence issues. We are a statewide provider of legal information and support for domestic violence providers. We're based in Oakland, and we serve all of California. We have screened hundreds of requests, I think it might be 1,000 by now, for assistance since we started in 2012, which was 6 years ago. We are building a body of published appellate decisions, helping survivors of abuse in California, and we provide trainings on many topics to attorneys and advocates like this training. And my name is Nancy Lemon, by the way. I'm the legal director and one of the co-founders of FVAP. This was originally part of a whole day training, so that's what slide number 5 is relating to, but right now we're just doing this one part of it. We want to thank Marcy Fukuroda and Manett Phelps and Phillips, a law firm who wrote Legal Issues for Domestic Violence Shelters in California. It was published in 2007 by the California Women's Law Center. And also funding for this came from the Blue Shield of California Foundation. Parts of this training are based on that document. Other parts of the training are based on materials from the Confidentiality Institute, which is headed by an attorney named Alicia Aiken, and the National Network to End Domestic to all of those folks. Our overview for today, we're going to talk about both confidentiality and privileges. Within confidentiality, first we'll have a short introduction, and then we'll talk about protecting confidential client information and laws prohibiting disclosure of a shelter's address. Under privileges, a short introduction, and then we'll spend a lot of time on the Domestic Violence Council, a bit of time on other relevant California privilege laws. So, if we were doing this live, I would now give you a true-false quiz, and you would fill it out, and we would also go over it at the end. But we're not going to do that because it's a webinar. So, introduction. Domestic violence protects safety of clients by keeping their information confidential. Shelters do this. This can be challenging because shelters are sometimes served with subpoenas. Also, private and government funders may require personal information about clients, which becomes problematic. And furthermore, law enforcement, prosecutors, and child protective workers may seek information when they're investigating cases. There are state and federal laws that protect client information with some exceptions, like child abuse. They also dictate how to respond to requests for information. All employees and volunteers at domestic violence agencies need to know how to effectively protect confidential information and to understand the legal rights and obligations that the laws create for shelters and their clients. So, Part B, protecting confidential client information. What is privacy? We're defining it today as a personal choice whether to disclose information. Then there's confidentiality, which is a responsibility to protect someone else's choices about disclosure of information. And then there's privilege, which is a legal rule, which is prohibiting disclosure of private information against somebody's will. And we have a handout, which you can access through our trainings website, which talks about that. So here's a graph showing that the privileged information is in the court or legal context, and that's a subset of the larger set, which is confidential information. So why do confidentiality and privilege matter if my client has already told many people about the abuse? Good question. Here's some possible answers. State law mandates that domestic violence counselors keep the information confidential. Secondly, the client may not want the information shared with certain parties. Third, the client may not want the information used in court. Fourth, the information might be used against the client. And there may be other answers that you might think of. So we do have laws that prohibit disclosure of personally identifying client information, which is a very important part of confidentiality. Requesting or requiring use of software that includes personally identifying information about victims of domestic violence, dating violence, sexual assault, or stalking. And what is personally identifying information? Well, it includes the name of the client or the name of the client's children, the client's home address, their email address, their phone number, their social security number, and their so the year that they were born is okay because that doesn't actually identify them. There's a Domestic Violence Shelter-Based Programs Act. So if you get marriage license fees from your county, then this act prohibits the county from requiring you to give that type of information, the personally identifying information about clients and also about employees or volunteers or the shelter address, if that's confidential. The county may request only the number of people that request services, how many you served, and a description of the social and economic characteristics of the clients, just very general. There is an exception for reporting child abuse, and that will be discussed later. Then there's the Violence Against Women Act. Who here gets VAWA money? VAWA prohibits agencies from disclosing personally identifying information, the same group, that is clients that are victims of domestic violence, dating violence, sexual assault, or stalking. And it also includes information about people who merely request the services or they're denied services by the agency. So it's not just people that receive services or clients. Again, there's an exception in terms of reporting child abuse. Another federal law that prohibits disclosure of this information relates to HUD. Many shelters get HUD funding and Homeless Management Information System. They're related to that, HMIS. That's a national computerized database, and that does collect personal information about clients. However, VAWA prohibits victim service providers from disclosing this information, personally identifying information, and victim service provider is defined in VAWA as nonprofits, including rape crisis, domestic violence shelters, domestic violence transitional housing, and similar programs. What it is designed to get information about is actually general homeless housing programs. So there's an exception for domestic violence and sexual assault agencies. So what if the California law is stronger and more protective than the federal law regarding confidentiality of the client information? The answer is the strongest and most protective law is the one that you should follow. Continuing with this topic, it's important to try to determine if there's another way to accomplish the purpose if somebody's asking you for that information without you releasing personally identifying information. If you do have to disclose the information, you should get the client's consent in writing ahead of time, and we'll talk about how to do that. and you should give only the minimum amount necessary to accomplish the client's purpose or to meet the reporting requirements, such as in child abuse cases. You should also give the client options about how the information is transmitted to the other agency or the requester. Does the client want this transmitted by email, by phone, by letter, by fax, through Dropbox, etc., so that the client can choose what they believe is the most secure means. Furthermore, any waiver by the client should be very time limited, just a few minutes, hours, or days. There is the Confidentiality Institute, which is part of the National Network to End Domestic Violence, recommends the shorter, the better. And we'll talk about waivers a little bit more. Keeping shelter addresses confidential is also related to a California statute in the Penal Code. It's a misdemeanor to maliciously disclose the confidential location of a domestic violence or trafficking shelter. And custody and visitation orders should keep the address of the victim parent confidential if that's what that parent wants. So if the shelter applies for funding under the Domestic Violence Shelter-Based Programs Act, which I mentioned earlier, the county may not require disclosure of the shelter's confidential location or the identities of residents, employees, or volunteers. I just want to point out on this slide, the first point, that it is only if the disclosure is malicious that there's a problem. So if it's accidental or negligent, that's not actually a crime. Our state has a public policy to protect confidentiality of shelter locations and other information that could jeopardize somebody's safety. So if you're faced with a request or a court order to disclose the shelter address, you may cite to these laws, even if they don't specifically apply, and you can say, well, this is part of our state public policy. You can always offer to provide your business address, and it's a good idea to consult with an attorney before you respond. You can contact us as well. So now we're going to talk about privileges, and the introduction to that. We're going to talk about California statutes right now. Our state law recognizes several statutory privileges that protect client information. The main one we'll talk about today is the Domestic Violence Counselor Victim Privilege. I'll briefly mention Sexual Assault Counselor Victim Privilege and the Human Trafficking Caseworker Victim Privilege. I'm not going to talk about therapist-patient privilege or attorney-client privilege or doctor-patient privilege, but those also exist. So, the Domestic Violence Counselor Victim Privilege. This is covered in Evidence Code sections 1037 and the sections following that. There's a handout that is a copy of those sections. So it might be good to right now take a minute and look at that. These statutes protect the confidential victim/survivor and their domestic violence counselor. The goal is to encourage domestic violence victims to seek counseling and help by enabling them to safely and confidentially discuss their situation and options with a qualified domestic violence counselor. However, the counselor may have to testify if the court orders it. We'll talk about that. So, it applies when testimony or records are sought as part of a legal matter in court or an administrative hearing, for example, in front of the Labor Commissioner, a Workers' Comp Appeals Board, Social Services hearing, that sort of thing, or some other proceeding, for example, congressional or legislative hearings. The victim has a legal right to refuse to testify about the protected information in any of these settings: court, deposition, written declaration. They also have the right to disclose or produce a writing, object, or a thing that's related to the protected information, like their notes or some photos. And they have the legal right to prevent another person from testifying or producing a writing, object, or thing related to the information. So that other person might be you. This privilege applies only if the requested information about the client is in fact kept confidential by the client and by the agency. Privileged information should never be released to third parties without the client's consent, even when the request is not made in connection with a formal proceeding. For example, let's say your agency gets a letter from the father's attorney, and in the letter, the attorney is requesting the records relating to the children's stay in the shelter because the father has joint legal custody order. That is privileged information and cannot be released without the client's consent. So there's a difference between privilege on the one hand and confidentiality on the other hand. Legal privilege, like the domestic violence counselor victim privilege, protects information that is confidential. However, like I showed you in that chart with the big circle and the smaller circle inside, not all confidential information is actually privileged. So, in what is privileged? To have the legal status of being privileged, the information between the client and the counselor must not only be communicated to the counselor, but a third party, like the abuser or the father in our hypothetical, must be trying to use it in a legal proceeding. That's when it becomes privileged. So, this difference between privileged and confidential information arises when a domestic violence agency is served with a subpoena or court order demanding disclosure of confidential information. The agency and the victim or client can assert the domestic violence victim privilege and must refuse to disclose the confidential information. Well, the DV advocate that she thinks the latest incident of abuse by her boyfriend might be her fault. So, is this statement confidential? Yes or no? The answer is yes. Statements made to a domestic violence advocate who have completed the required training are usually confidential. We'll talk about child abuse as an exception later. Question 2. Is the same statement by this new shelter resident that the abuse is called privileged? Is that yes or no? What do you think? The answer is yes, if a third party, such as an alleged abuser, tries to obtain the statement or document to use in a court proceeding, then the issue of privilege arises. So here, her statement that it might be her fault could be helpful to the abuser in defending against a criminal charge of domestic violence. If the abuser found out about that statement and tried to get the domestic violence advocate to testify, the advocate should assert the privilege and refuse to testify. It's really good that California has such a privilege in our laws. However, most challenges to client information occur in daily life where privilege and courts are not involved. Therefore, it's really important to adopt and use strong confidentiality practices, which I talked about a little already. I'll talk about more, to protect survivor privacy all the time. So, next question. Who holds this privilege? Is it the domestic violence counselor? Is it the agency? Is it the client or victim of domestic violence? The answer is that it's the victim. I'm using the term that's used in the evidence code here, by the way, even though we tend to use the word survivor more these days. That's the person that holds the privilege. It's the only person who can decide whether to disclose privileged information. If this person has a guardian or conservator, they can decide, unless they are accused of domestic violence against the victim. But that's pretty unusual, so usually it is the victim themselves. and former clients continue to hold that privilege. So, what's the difference between the holder of the privilege and who can claim the privilege on the holder's behalf? Who can claim the privilege other than the holder or the victim? Is it the DV agency? How about the DV counselor? How about the victim's next of kin? What do you think? Well, the answer is that the domestic violence counselor or anyone authorized by the holder of the privilege may claim it. And that person, the counselor with whom the victim communicated, must claim the privilege whenever a request for the victim's confidential information is made in the counselor's presence. So this is mandatory. Then the counselor is supposed to consult with the holder, usually that's the victim, unless the victim already consented to disclosure of that statement, like I think it was my fault, or if the victim is dead, then there is no privilege anymore, and they died without a guardian or conservator. So the privilege dies with the victim unless there's a guardian or conservator. And if there is, the DV counselor and or agency should consult with that person regarding whether the counselor should claim the privilege. The statute does not provide that the victim's next of kin holds the privilege, so they don't. And we'll cover responding to subpoenas in another training. So here's a tip. When you first consult with a domestic violence victim, ask if they are willing to sign a form authorizing members of your staff to claim the privilege on their behalf. There's a handout called Client Authorization, and you can take a minute to read that. This helps protect the victim's information if there's a request for information that's not made directly to that domestic violence counselor or to the victim. For example, it might go to the executive director or to the director of operations as controllers of the agency records. But of course, even without the form, the information cannot be disclosed unless the victim specifically agrees to allow this. So who qualifies as a domestic violence counselor who is covered by this privilege? You've got 4 options here, and you get to think about which of the 4 you think qualifies. First, any staff member or volunteer at a domestic violence agency, no matter what their training or supervision is. 2, all staff members and volunteers who counsel domestic violence victims, no matter what their training or supervision is. 3, all staff members and volunteers who have completed the 40-hour domestic violence training. Or 4, all staff members and volunteers who have worked at a domestic violence agency less than 6 months, but under the supervision of a domestic violence counselor who's been there at least 1 year. The answer is 3 and 4. Those 2 options are correct. So a domestic violence counselor without a graduate degree in counseling is either an employee or volunteer of a domestic violence service organization who counsels or assists DV victims and who's completed the 40-hour training for domestic violence counselors, or if they have not completed the training, if they've worked at a DV agency less than 6 months, they must be supervised by someone with at least 1 year of experience as a domestic violence counselor. They can also qualify as a domestic violence counselor if the person has a master's degree in counseling or a related field, even if they didn't complete the 40-hour training. So that would be social workers and therapists with graduate degrees. Note, a domestic violence counselor employed by a domestic violence agency who works at another agency, for example, Child Protective Services or the DA's office or a police department or a hospital, is still a domestic violence counselor as long as they fit one of the above categories. So just to recoup, who's a domestic violence counselor for purposes of the privilege? Either they have to have completed the 40-hour training, or if they worked at the agency less than 6 months, they need to be supervised with someone with at least 1 year experience as a domestic violence counselor, or they need to have a graduate degree in counseling or a related field. So because privilege doesn't actually apply unless somebody qualifies as a domestic violence counselor under the evidence code, one of those three categories we just looked at, it's important for all domestic violence agencies to have written policies about training or certification processes for all of their advocates, and records documenting when the training took place, who got certified, and who's supervising whom. So, next question, what is a domestic violence victim service organization? The answer, according to the evidence code, is a non-governmental organization that provides shelter, programs, or services to domestic violence victims and their children. So you don't actually have to have a shelter. It includes domestic violence shelters and other programs whose primary mission is to provide domestic violence services, even if that group is part of a larger agency. It might be a program that's part of a larger agency that's providing other services to the community. I know there's a lot of programs like that throughout our very large state. So what if a domestic violence counselor works for a program that's part of a larger agency whose primary focus is not domestic violence services? How can that counselor maintain confidentiality so the client information is privileged if it is sought for a legal proceeding? Well, the answer is you have to create a confidentiality wall between the domestic violence program records and the records of the larger agency. You need to store the hard copy domestic violence program records in a separate locked filing cabinet and separate databases for the electronic versions of records. Also, the staff and volunteers for both the smaller agency and the larger one need to sign written agreements to keep the domestic violence client information confidential from the umbrella agency, the larger agency. And furthermore, you need a wall between the mandated child abuse reporters and the other employee reporters. So what if the domestic violence agency stores some of its client records in Dropbox, Google Drive, or other cloud-based platforms? So the answer to that is that the IT contractors that are working with your agency should sign a confidentiality agreement. And when storing client records in the cloud, as with other client records, less information is best because we know that able to get in to these cloud-based services. If your agency maintains proper oversight and control of the data that's stored in the cloud or offsite, the survivor does not need to consent to the electronic storage. So a tip is to check the standard terms of the offsite storage company, like Dropbox, to make sure that it provides that they will not disclose any stored information. You might be looking for a non-disclosure agreement, or NDA. So here's another question. Would someone who's a confidential advocate at a college or university in California qualify under the domestic violence counselor victim privilege? Yes or no? The answer is yes. Last year, advocates at institutions of higher education did not qualify for the privilege. That was in 2017. But starting in January of 2018, they do. This is because Hannah Beth Jackson carried a bill, Senate Bill 331, which amended the evidence code. And now it says the victim service organization includes programs on the campus of a public or private institution of higher education with a primary mission to provide support or advocacy services to victims of domestic violence. Here's another question. Would a domestic violence victim advocate working for victim witness assistance who completed 40 hours of domestic violence training be able to assert this privilege? Yes or no? The answer is no. Victim witness staff work for governmental organizations like prosecutors' offices, so they don't qualify under the privilege, even if their job title is, quote, DV advocate. They have to work for a non-governmental organization to qualify. This is very confusing for domestic violence survivors who may assume that anybody that says they're a, quote, domestic violence advocate holds the privilege. So it's important for you to explain this to clients before they meet with victim witness staff, that it's not confidential. And especially if they say something to that person like, I think the last time when my boyfriend and I got into it, maybe it was my fault. That is a very important statement for them to think about whether they really want to say that to victim witness, given that it's not confidential. So what kind of information is protected by the privilege? The answer is a confidential communication, which is defined as information exchanged in confidence between the victim and the counselor in the course of their relationship. This includes written, oral, or other information about abuse, about the children of the victim and abuser, and about the relationship between the victim and the abuser. We have a broad definition of confidential communication that's subject to the privilege. I should say that at this point in time, June of 2018, there is actually no appellate decision from the California courts. Even though we've had this domestic violence privilege for a very long time, there's no decision that actually interprets the privilege. So sometimes what we're doing here, as on this slide, is analogizing from other privileges. Here, in the case called Smith versus Superior Court back in 1981, this one dealt with a therapist-client privilege, which is similar but not identical to domestic violence counselor victim privilege. But that court held that even the identity of the client was privileged information. And that included the client's name, address, and phone number. So that needs to be kept confidential. And the court also said that disclosing the client's identity can reveal the fact that the client suffers from a particular condition. In this case, they're going, in that case, they were going to a therapist. In addition, protecting the identity of the client is part of providing a safe and candid forum in which to address the problem. So, in addition to those concerns in that Smith case, not a domestic violence case, domestic violence cases raise serious safety concerns for domestic violence victims, of course. It's key to keep the identity of the client confidential. Does the privilege apply only to oral communications between the counselor and the victim when you're talking to each other? Yes or no? The answer is no. The privilege also applies to written information and information transmitted electronically, such as a medical report, voicemails, emails, texts, faxes. I would also add photos, because the victim might be giving you photos showing injuries on their body. In general, less is best in written records regarding clients. It's important to ask yourself, is this information actually necessary to record? What is needed to do your work? It's fine to include the dates of contact with the client, referrals that you made to the client, and activities, such as client came to support group on Wednesday night. It's fine to include public records like police reports or a description of the abuser and their vehicle in case the abuser shows up. It's good for agencies to have written policies about what to include in the records, because the court may order some of these confidential records to be disclosed in some cases. Don't include your own subjective opinions about the client. And don't include whether the client has substance abuse issues or any diagnoses that they might have, or the client's verbatim statements or letters that the client wrote, or the details of the client's safety plan, because information that you may think is helpful to the client may be used against them. So here's a question. So what do you do in terms of communicating with other staff if you have an opinion about a client or other information that might be used against the client if you do not record it in the client file? The answer is that it's best to communicate orally with the other staff if there's information that might be used against the client, because, as I keep saying, this privilege is not absolute. The court might order records to be disclosed. And we'll talk about that later in the section on subpoenas. So talk to the other staff, don't write it down. Another question, what is a confidential communication for purposes of this privilege, the domestic violence counselor victim privilege? The answer is that it's a communication made in a manner which, so far as the victim is aware, discloses information to no unnecessary third parties. So you can see that we have bolded that word unnecessary. So you're going to be talking about that. We'll give you an example. If the domestic violence counselor and victim are having a conversation in the reception area of the administrative office of the agency, and they're surrounded by people who can easily overhear their conversation, like the receptionist, perhaps. The question is that communication confidential and thus privileged if a third party, like the abuser, seeks to use it in court? Yes or no? What do you think? The answer is no. The victim does not have a reasonable expectation that anything that she or he says during the conversation is in confidence, so it would not be privileged if someone else wanted to use it in court. Therefore, it's critical that consultations between domestic violence counselors and clients or victims take place in private, out of the presence and earshot of third parties, so that they are confidential, and thus, if a court gets involved, they would be privileged. So what if one domestic violence counselor consults with another one at the same agency in a private office discussing the client's situation? Does that waive the privilege? Is that an unnecessary third party? The answer is no, because the second counselor is being consulted for the purpose that the client is trying to achieve, and the communication is not in a public setting. In this context, the second domestic violence counselor is a necessary third party. Ensuring privacy is not always easy. Many times, domestic violence counselors are in public places with the victim, like a hospital, a courthouse, or at the scene of a domestic violence incident. So what should the counselor do to maintain confidentiality in that type of situation? The answer is that the counselor should consult with the victim in a separate area or a separate room away from third parties. You can say things like, let's walk down the hall here to talk about that, or let's step outside so we can have a confidential discussion. What if they're talking on the phone? How can the domestic violence counselor ensure that the communication is confidential so the privilege applies? The answer is ask the victim if they're alone. If they're not, ask them to move to a private place, or maybe they can ask the third parties to leave the area. So necessary third parties. Sometimes communications that are disclosed to third parties are still privileged if the third party's presence furthers the interest of the victim in the consultation. Like I gave that example before where one counselor is talking to another one in a private office. Or if the disclosure to the third party is reasonably necessary to transmit information between the victim and the counselor. For example, an interpreter. Or disclosure to the third party is reasonably necessary to accomplish the purpose for which the counselor is consulted. So, some examples of these necessary third parties. The victim may need an American Sign Language interpreter or an oral non-English language interpreter. That's fine. Also, caretakers and support people for disabled domestic violence victims, or if the victim needs emotional support in order to speak to the counselor. They are necessary third parties. Staff or volunteers who are not formally domestic violence counselors, but who are working under the supervision of the counselor and are assisting the client are also necessary third parties. For example, if the victim is talking to a social worker and then the social worker has an intern working with the client under the supervision of the social worker, they would be a necessary third party. It's important to document in the client file why the third party was present and that they were necessary. That helps keep the communication confidential and therefore privileged. So what if the client makes a statement to a student intern who works under the supervision of a licensed psychologist who's on the staff, but the intern has not completed the 40-hour training? Is that statement covered by the domestic violence victim privilege if somebody's seeking it for court? Yes or no? The answer is yes, that is protected. Students working under the supervision of a professional who's subject to a legal privilege are covered by that privilege. We also see that with law students working under the supervision of an attorney, for example. What professionals subject to various privilege might work at a domestic violence agency? Lawyers, licensed clinical social workers, psychotherapists, anyone else? Anybody working under their supervision is covered by their privilege. Domestic violence counselors can use the expertise of others on staff or volunteers without destroying the privileged nature of the communication that the victim is sharing. However, that communication, as I said earlier, with the third party must be made in confidence, like out of the earshot of other people, and the domestic violence counselor must supervise the third party's interactions with the victim. The counselor and the third party should check in often regarding what's happening with the victim. Like if there's a social worker on staff, the two of them should be consulting about this client. What if the domestic violence counselor asks a doctor or therapist to evaluate the client, such as, does this client have PTSD? Is a report from that professional to the counselor confidential? The answer is yes. Courts have held that such reports are covered by attorney-client privilege where the attorney requested them, so they should be covered by the domestic violence counselor victim privilege. Here's a tip. Before asking the third party to become involved with the client, review their confidentiality agreement to make sure that it keeps the client information confidential. Domestic violence counselors can also ask for similar reports which are confidential if they're reasonably necessary to transmit information about the victim's condition to the counselor, like, does this person have PTSD? That is furthering the interest of the victim, and it helps accomplish a purpose of the victim's consultation with the DV counselor. Reports may also be protected by physician-patient privilege, of course, or therapist-patient privilege, depending on who wrote the report. What if the victim is coming to the support group? I mentioned a support group earlier, and they disclose information in the support group at the agency. Is that information confidential? Because there's now a whole bunch of people involved, and therefore it would be privileged if the abuser wanted it. Is that yes or no? The answer is yes. Participating in support groups is reasonably necessary to accomplish a purpose for which the victim consulted the domestic violence counselor, which is to obtain supportive services that help the victim recover from abuse. So that's fine. It's still confidential and therefore would be privileged if somebody was seeking it for court. And what should the counselor do if they're not sure if the third party is covered by these exceptions, like to make them a necessary third party? The answer is to advise the client that any information that's shared with a third party will not be or may not be protected by the privilege. Even if the third party clearly falls within one of the exceptions, it's still best to have them sign an agreement saying that the information that's being disclosed is confidential and privileged, and they must not disclose any information about this client to other third parties. What about waiving the privilege? Confidential information that's protected by the privilege may be disclosed if the privilege is waived or if information falls within an exception to the privilege. And who can waive the privilege? Can the domestic violence counselor waive it? How about the victim? How about the victim's guardian or conservator? The answer is that the holder of the privilege, who's the victim or their guardian or conservator, is the only person who can waive the privilege. There is an exception for mandated reporters of child abuse, and they can waive the privilege, and that will be discussed in another training. So it's important for agencies to have written policies regarding confidentiality of communications with the clients, and the client's informed consent for waiver or release, and how clients are informed about these policies. How can the holder waive the privilege? There are several ways. First of all, consenting to disclosure of privileged information, like formally, or 2, voluntarily disclosing information to a third party, or 3, failing to claim the privilege when protected information was requested on a previous occasion. We're going to discuss each of these 3 points in some depth. The first point, consent. What does consent to disclosure consist of? The answer is any statement or conduct that indicates consent is sufficient to waive the privilege. So here's a tip, best practice. Take steps to ensure that the domestic violence counselor obtains clear and specific consent from the client before disclosing privileged information. It should be informed consent. The counselor should advise the client of the scope and limits of privilege and the potential consequences if it's waived. Let's say that example I gave earlier where the client says, well, gee, the last time we had an incident, maybe it was my fault. And now somebody's asking for that information. The counselor can talk to the client about the potential consequences. Namely, that could completely derail the criminal case, for example, or it could be a problem in a family law custody fight. And in terms of consequences, once that information is waived for one purpose, it's waived for all purposes. That means that the counselor can no longer claim the privilege in another context, unless there is limiting language in a written consent form specifying for what purposes the client is agreeing that the information can be used. What's an example of waived, quote, for all purposes? So if your client agrees to waive the privilege to allow you, the domestic violence counselor, to talk to Child Protective Services, later on, the abuser could require you to testify about that information in a restraining order case, a divorce case, or a custody case. But you should still try to assert the privilege. So how do you avoid that? Consent needs to be in writing. This helps the client understand the significance of waiving the privilege, and it creates a record in the event that the domestic violence counselor is faced with a later request for information. We have a handout that you can give the client, which is giving consent. Third party is asking for confidential client information, but you can't get written consent from the client. The answer is try to set up a 3-way call with the client and the other agency so the client is communicating their consent to release specific information over the phone, or you can read the consent form to the client on the phone, note that they okayed it on whatever date, and then signature later on as soon as you can. Point 3, consent should be narrowly tailored. The goal is to accomplish a specific purpose for which the information is being disclosed. You, the domestic violence counselor, can adapt the standard consent form that we have for you to address the client's individual needs. And it's best to limit the type and amount of information that is disclosed. Common ways to limit the client's consent to disclosure include specifying the entity or person to whom the information is being disclosed, not just anybody, and state on this form the purpose for which it's being disclosed, and specify the type and scope of information being disclosed. It's always important to place a time limit on the client's consent. The shorter the better. You can extend the time later if needed. If the client signs the waiver, but no information is then disclosed during that time period, the privilege is not waived. Any later request for the same information would require a new consent form. Consent to waive the privilege, of course, should not be obtained by coercion or duress. To be valid, consent always has to be voluntary. This might arise if the client signs a waiver at the scene of a domestic violence incident. They may be in crisis. They may not understand the waiver. They may think signing is a condition of getting help from the police or from you. So the best practice is to wait until a calmer time to talk about waiving the privilege. It's important to avoid blanket consent forms as a condition of receiving services. That might allow the counselor to disclose privileged information to police, child welfare agencies, funders, etc. Because then the clients might feel pressure to do that, to sign that in order to get services. That is not informed consent regarding which information might be released to which third party. So the best practice is to ask the client to sign the form when dealing with a specific request for the client's confidential information that's coming in from a third party. So here's a question. What about minors? Some agencies are serving teens, for example, like teens can get restraining orders from age 12 and up in California. Can minors consent to disclosure of their client records without the consent of a parent or guardian? Yes, no, or now I'm giving you a third option. It depends. And the answer is it depends, which we lawyers like a lot. If minors are legally allowed to receive services from you without the consent of a parent or guardian, they may also consent to disclosure of their information without consent of that parent or guardian. However, if parental or guardian consent is needed before your agency can serve the minor, then the parent or guardian and the minor must both sign the release of confidential information form. So a tip is that when you're working with teens, try to use non-mandated reporters of child abuse, because if they are under 18, then that child abuse reporting law might apply. So what if your agency receives a form that a client signed at another agency requesting your agency's records? The answer is meet with the client, advise the client about the consequences of the waiver, determine whether the client is voluntarily requesting disclosure of these records, and if they agree, then have the client sign a specific waiver form allowing your agency to release the records, just like the form that we looked at earlier. It's important for agencies to have written policies about this situation. If your agency is often receiving blanket release forms from other agencies, for example, Child Protective Services or HUD, consider meeting with the other agency to discuss why such forms are problematic because of the domestic violence counselor victim privilege. You can discuss with them what procedures would be better. For example, a time-limited waiver asking for specific information. You can tell them that your agency needs to meet with a client, that the victim holds the privilege, and that consent needs to be voluntary and informed. So, basic elements of the client's consent to waive the privilege needs to be in writing, dated and signed by the client. It needs to include the name of the person or entity who's authorized to disclose the information, which might be you. It needs to include the name of the person or entity to whom the information is to be disclosed, like maybe CPS. It needs to state what information will be disclosed and the purpose of that. And it needs to state that the client has been advised of and understands that the information is protected by the domestic violence counselor victim privilege and perhaps by some other laws. And finally, it needs to include the date or event upon which the consent expires. So here's a note about mandated reporters. If the domestic violence counselor who is not a mandated reporter of child abuse is transferring confidential information to another domestic violence agency, first ask if the recipient is a mandated reporter of child abuse. If they are, and there are no employees at the receiving agency who are not mandated reporters, it's good to discuss the options with the victim client before you are transferring that information, because it might end up being reported when the client has not really been aware that that's a possible consequence. Can the holder of the privilege revoke consent to disclosure of the privileged information? Yes or no? The answer is yes. The victim or survivor can revoke consent to disclosure at any time, orally or in writing. Voluntary disclosure. The holder can waive the privilege by disclosing significant parts of the communication to a third party who is not covered by an exception, is described above, like their sister or their friend. The privilege is waived only with regard to that one subject, not all communications with the domestic violence counselor. The holder must disclose a significant part of the communication for it to be a voluntary disclosure. So, as an example, let's say the client discloses to their sister only that they sought treatment from a domestic violence counselor. That's not a waiver of privilege as to all the communications with the counselor. Also, the domestic violence counselor can provide the client with a letter confirming that they sought services from the agency without waiving the privilege, but do not include an opinion in the letter that the client is actually a victim of domestic violence. The disclosure must be intentional by the holder to constitute waiver. So, for example, let's say you accidentally include a document from the client file that's going in a package to a third party. There is no waiver because the client did not intend disclosure. This was not intentional, it was accidental. Here's another question. What if the client tells a friend about their conversation with you and asks the friend to keep the information confidential? Is the privilege waived? Yes or no? The answer is yes. In this case, the privilege is waived, even if the client asks the friend to keep this information confidential, because the client intentionally disclosed information about their conversation with you. So privilege disclosures don't waive confidentiality. For example, if the client asks you to send records to their attorney, the client's communications with the attorney are covered by attorney-client privilege. And the counselor can ask the client to sign a release form stating that this is intended to be confidential communication to their attorney. So it's not waiving the domestic violence counselor victim privilege. What about failure to claim the privilege? If the holder has the ability and opportunity to claim the privilege but fails to do so, it is waived. The failure to claim the privilege can be manifested through words or conduct. And there's also limits to the privilege. The counselor must advise the victim orally or in writing prior to beginning to have a conversation with the client about these limits. One is child abuse reporting. Two, three, if there's a qualified privilege. So we'll talk about that. Danger to self or others. Has anybody watching this worked with a survivor who you felt was a danger to themselves? What did you do? What about a survivor who you felt was a danger to others? How did you handle that? The Evidence Code doesn't actually address this for non-therapists, and as I said earlier, there are no cases in victim privilege from our appellate courts, and there's no federal duty to warn other people that they might be in danger. However, confidentiality still applies. Do you have an agency policy on these? It would be good to have one. What if a shelter resident becomes unconscious? Answer, confidentiality still applies. In an emergency, when you can't get consent to release the client's confidential information, give the responders, like the EMTs, as little information as possible. For example, you could say that this is a woman and she's 42 and she turned gray and then she passed out. It's best to have written agreements with the residents at the shelter prior to emergencies, which would allow you to disclose that kind of information if it were an emergency. And I also talked a little bit earlier about, quote, qualified privilege. What does that mean? Well, the answer is that the court may order your agency to disclose the victim's information. if the court decides that the information is relevant to the proceeding, and if its value to the proceeding, like the trial, outweighs any negative impact that will result from disclosure. That will be covered in the subpoena part of the training. What if the counselor works for a domestic violence response team with the police and maybe with prosecutors? Who here is part of a DVRT or a DART? So domestic violence abuse response teams are formal partnerships between law enforcement, prosecutors, victim service providers, and other community professionals to provide support to victims at the scene of a domestic violence incident and later on. These teams can lead to confusion among team members and domestic violence victims regarding whether the counselor's communications with the victim are privileged. Other team members, like police and the prosecutors, are not subject to statutory privileges. So that's very different from the domestic violence counselor. The police and the district attorneys have different objectives than does the domestic violence counselor. They're gathering evidence while the counselor is providing support to the victim. Even as part of one of these teams, the domestic violence counselor's communications with the victim are privileged. It's important to ensure that the conversation with the victim is private, out of earshot of other team members. As we talked about earlier, you say to the victim, let's step outside so we can talk about this confidentially, or let's walk down the hallway, or let's go into the kitchen, wherever you can go that's away from the other team members. Then you tell the victim about the scope and limits of the domestic violence counselor victim privilege, and tell them that their communications with the other team members may not be privileged. So that statement, gee, I think maybe it was my fault, they may want to not say that to the law enforcement members of the team. So what if the victim or survivor wants somebody else present during the interview with the domestic violence counselor at the scene of the incident, like their friend? Does this destroy the privilege? Yes or no? No, since the support person is present to assist the victim in talking to the domestic violence counselor, they're really a necessary third party. So their presence should not destroy confidentiality. However, of course, you should always exclude the suspected abuser, even if the victim says that they want the abuser present for support. And prior to an interview with law enforcement, prosecution, or a defense attorney, the domestic violence advocate should advise the victim of any applicable limitations on the confidentiality of communications between the victim and the advocate. So the advocate here in this particular example that I'm talking about includes victim witness staff. They are required by law to tell any clients or victims that anything that is said to them may have to be disclosed to the prosecutor. And many of you are probably familiar with the Supreme Court case called Brady, which requires that the prosecutor turn over any possibly helpful information or evidence to the defense, like a statement like, gee, I think maybe it was my fault. So if we were doing this in real time and we had lots of time, we might do a role play right now. One of you being the counselor, the other is the victim. There's a couple members of the domestic violence response team that are present. They're law enforcement officers. What do you say to the victim? What do you say to the officers? How do you assert yourself and inform the victim of this right to keep things confidential and go out of earshot of the officers? And then we would report back. How was that for you? Was it hard? What's the best way to handle that situation? It's good to practice ahead of time before you're in that situation. The domestic violence counselor may be present when the victim talks to other members of the team, for example, law enforcement, because the counselor is there to provide emotional support. However, the domestic violence counselor victim privilege does not apply to those communications because now we have third parties that are there who are not necessary third parties for the victim to communicate with you. So do not sign any memorandum of understanding that requires the counselor to share the victim's confidential information with other members of the domestic violence response team. It's only the victim that can waive that privilege. You cannot waive it. What if your agency is serving on a task force, for example, the County Family Violence Council or Roundtable? You still need a specific release from each survivor, unless they have died, to discuss anything about their case. You can just talk generally about domestic violence cases and how things are going in your county and how they could be improved. A written blanket agreement with other task force members to share information about mutual clients is unenforceable, and it does not comply with the evidence code requirements for the domestic violence victim counselor privilege. So it's best not to sign one of those. Excuse me. Can you write a support letter or a declaration in support of the client's family law case or their application for a restraining order? Like, the client came to see me, we discussed their case, they told me that they were beaten up 3 days ago, etc. Yes, no, or it depends. The answer is, it's generally best to just submit a letter confirming that the client sought services, as I mentioned before. Be cautious about becoming a witness in the case, unless the client actually asks you to do that, because that would waive the privilege. You need to advise the client of the ramifications of a waiver and get their written consent before you write a declaration or a letter. If the client consents, the counselor might be subpoenaed. We'll discuss that later in the training on subpoenas. And teen victims, I mentioned this earlier. If a minor is sufficiently old and mature, maybe 12 plus, they can exercise their own privilege rights. But if they have a legal guardian or conservator, that is the person who holds the privilege on behalf of them. So you need to verify whether the parent is their legal guardian before assuming that their parent has the privilege. It's possible the parent's rights may have been terminated. And the counselor may have to report abuse to this teen under child abuse laws. So it's critical to advise clients who are 12 plus up to 17 of the possible mandate to report child abuse at the beginning of your conversation. And part of the mandate is to tell all clients of any limits on confidentiality, as we mentioned. This is really important as part of building trust with your client, so they can decide what they're going to tell you. That's the end of domestic violence counselor victim privilege in this training. So now we'll talk about a couple other privileges. One of them is the sexual assault counselor victim privilege. Who works at an agency that also handles sexual assault cases? If your agency is not specifically funded to handle sexual assault cases, you are probably handling them anyway, because that shows up in domestic violence cases, of course. The scope and model of the sexual assault counselor victim privilege are generally the same as the domestic violence counselor victim privilege. There's only a couple of differences between them. One is that the domestic violence counselor privilege dies with the victim, as I mentioned before, but the sexual assault counselor privilege continues. After that victim dies, the personal representative of the sexual assault victim, who might be an executor or administrator of their estate, holds the privilege. Second difference is that there's no express exception in the sexual assault statute about mandatory child abuse reporting, unlike the domestic violence counselor victim privilege. So some sexual assault programs interpret that to mean the counselors don't have to report child abuse, and other programs require that child abuse be reported. There is no court decision, unfortunately, that would clarify this. And until the courts rule on it, the policy is really up to your agency. We'll discuss that more in the mandatory reporting section of the training. So there's one other privilege that we're going to talk about briefly, the human trafficking caseworker victim privilege. Who here deals with survivors of human trafficking? A lot of you. Traffickers also sometimes commit domestic violence or sexual assault. The Domestic Violence Counselor Victim Privilege and the Human Trafficking Caseworker Victim Privilege are very similar. And as with the domestic violence privilege, after the death of the human trafficking victim, nobody holds the privilege. So if we were in person here, I would give you the same quiz again, true, false, and compare your answers to the first time you took it to see if some of the things that you weren't sure about are now more clear. If you have any questions, you're welcome to email them to us at ffaplaw.org. Thank you for attending. Our staff includes Aaron Smith, myself, Jennifer Wagner, Sheree Garishi, Anya Emerson, Jason Hogue, and actually Corey Hernandez is now at another agency. Here's our address, our telephone number and fax, the website, and the money was developed in part from the U.S. Department of Justice through California OES. Thanks for watching our webinar. MCLE credit is available, as I said at the beginning, for completing the webinar. To obtain MCLE credit, download the evaluation form located below on the webpage for this training video and email it to training@ffaplaw.org or visit www.ffaplaw.org/training. While there, you can also browse our selection of other recorded trainings, which is getting to be a pretty great selection. A copy of these training slides and any accompanying materials is available on the webpage for this training video or by emailing training@ffaplaw.org. Thank you again for watching. This webinar is now concluded.